And and the point is to do it correctly, to do a good job for the client, it must be estate planning. And I know clients are concerned about fees. And when they say, I want a simple will, they probably think that'll cost less than estate planning. But to do a simple will means, I don't know what it means, quite honestly, but I can't just write a will in a vacuum without knowing more about the total picture of the client. So I'm going to give you a sense here of what I need to know and what I need to discuss with clients in doing their estate planning. It's not exhaustive what I'm going to talk about. And I'm not going to focus on any one issue particularly long. If I did, we'd be here a long time, and I know no one wants to do that. So let's get started. The first thing I want to know about client is information about their family. Obviously, you know, is there a spouse? Is there children? Are there siblings? Um, who are these people next of kin? Doesn't mean they're going to leave them anything, but I need to know that information. If there is a spouse, I need to know if there's a prenup, because the prenup may control estate issues. Sometimes people forget about that. I need to know if there's a divorce agreement from a prior marriage, because there might also be obligations about estate matters after terminating a prior marriage. And I need to know if any of the family members are what we call special needs persons, people who are living on government assistance, because we don't want to leave them money that might disqualify them for government assistance. And there are ways of dealing with that. So these are all questions one must discuss with the client when we first sit down. And then, of course, we'll talk about assets. Now, for most clients, their most important asset is their home, whether it's a co-op, a condo, or a house. We want to know, how is it titled? If they own it with a spouse, do they own it jointly? How is it titled? So we know what it is that they're able to give away in their will. Um, if they own a second home, like a vacation home, we also need to know how it's titled and who owns it together, because often if it's a second home that's been in the family for years, the family members may own it as co-owners. In some states, it's called a cottage agreement. And there are restrictions on how it can be transferred upon death in order to make sure that property remains in the family. Many clients have property, real property, in other countries. And we need to know what country it is and what the rules are there. Many European countries, particularly the Mediterranean ones, have forced heirship rules, meaning that when it comes to real property, house, land, it must remain in the family. You can't leave it to a trust. You can't leave it to friends or charities. They want to make sure it's going to stay in the family. So under those circumstances, we normally get an attorney in those countries involved, because obviously I'm not familiar with the law in other jurisdictions, particularly foreign ones. The next largest asset for most people are their qualified retirement accounts, which of course Ian is very familiar with. Those accounts can only be owned by the client, no joint owners. but they should have beneficiary designations. Without a beneficiary designation, a qualified retirement account goes into one's estate when they dies, and that's not a good thing. That triggers unwanted income tax consequences. So we have to ask them about those accounts. And then there are other accounts. They might not be retirement accounts, but they're investment accounts, bank accounts, and we have to know, how are they owned? Are they owned jointly with someone? Do they have beneficiary designations? All that will matter when we're doing a client's estate planning. So we need them to come in, if they don't know this information, we ask them to bring in account statements. Sometimes we get on the phone with their financial advisors while I'm talking with them to ask how accounts are titled. We also have to talk about what we call tangible personal property. Those are things, artwork, jewelry, collectibles, clothing, furniture, things as opposed to money and stock. For many people, they're of modest and inconsequential value. But for some people, there might be some items that are of particular value. And we need to address those. How do they wish to leave an important, a valuable item of tangible personal property? Now, some clients come in and want to say, I want to put in my will XYZ. And sometimes I discourage them from doing that, because if they are items of modest value, we don't need to put them in the will for a couple of reasons. One is it could trigger an audit from the taxing authorities wanting to know, well, if they put it in the will, it must be of significant value, so get an appraisal. I'm talking about when the testator dies, when the client dies. And why go through the expense of an appraisal if it's something that's of really modest value? The other reason I don't like to necessarily list such items in the will is because people might give them away while they're alive. And then when you probate the will, you'll run into a problem with the surrogates court. Well, where is this item? Why aren't you giving it to X? So unless they own a really valuable piece of tangible personal property, and I run into this very frequently with jewelry, because a lot of clients want to make sure, particularly women, that their jewelry goes to a specific person. And I respect that. But often I try to encourage them to put it all in a letter outside the will. Now, New York law, and again, as I mentioned earlier, I'm just talking about New York law. New York law is what's called the four corners of the will doctrine. If it's not in the will document, it's not enforceable. That's the policy that the surrogates court takes. But you can say in a will that I direct my executor, and we'll get to that in a minute about who your executor is, to abide by the instructions I have left in a separate will, separate and apart, in a separate document, separate and apart from this will, knowing, and you say this, that it may not be enforceable, but you expect my executor to abide by it. And very often we do that. And the other reason why we like doing that is because clients often lose items, give it away while they're, particularly jewelry. They might give something away to a grandchild or a friend. So we don't want to necessarily put every item in a will, but we will put it in a document outside the will and say that we expect the executor to abide by it, but we know that it's not enforceable. Now, there are other ways of leaving property to people outside of a will. and we call them testamentary substitutes. If you have a joint owner on an asset, such as a bank account, such as a house, co-op shares, joint owners, they inherit that asset automatically upon the death of the other person. It does not go through probate. We don't wait for the will. We don't care what the will says. The joint owner inherits automatically. The same thing with a beneficiary designation. If you have an account and you say, upon my death, it shall go to X, that person inherits automatically outside of the will. Again, we don't care what the will says. The beneficiary designation has control. And the takeaway from this is, if you have beneficiary designations, be sure to check on them now and then. Check with your account holders, your financial advisors. What did I say 10, 20 years ago? Is that still what I want? And also make sure that they've done what you want, because often a beneficiary designation gets lost through the cracks. And if you die and it's not there, well, it's too late. There is no beneficiary designation. Recently, very recently, New York adopted what's called a transfer on death deed. It refers to real property, a house, a condominium. These are assets that have deeds that are filed with the county clerk. And you can now, under this change in the law, while you're alive, change the deed to say, upon my death, this property shall go to X, Y, or Z. You can change it while you're alive, but each time you change it, you have to record a new transfer on death deed with the county clerk. This does not relate to co-ops. Co-ops are owned through shares, and this law does not refer to shares. It only refers to real property like houses and condominiums. So for many Manhattan people who own co-op shares, they can't do this. And of course, I don't need to remind those who own co-ops, you have to go through the approval process with co-op boards, which can be onerous. And they don't want shares that say immediately upon death, these shares will be owned by X, because they want to be able to approve who's owning the shares. Another very significant testamentary substitute is a revocable living trust. So when it was asked while we were just gathering here before Ian started the program about trusts, this is one type of trust. There are many types of trusts. This is one type of trust that a client might create while he or she is alive. It's revocable, meaning the client can change it at any time, can terminate it, can change the terms. It's living, meaning the client creates it while the client is alive. And it's a trust, meaning I put it into the name of a trust. I'll be the trustee while I'm alive and of sound mind. But when I die, the trust agreement will say how the assets will be distributed, just like a will. It's a substitute for a will. The takeaway is, and this is extremely important because clients really get confused when they listen to, sorry, Ian, but they listen to financial advisors late at night.
No offense.
There is no estate tax saving for doing a revocable living trust. Zero estate tax. Zero. Uncle Sam's not that stupid, because everyone then would create revocable living trusts. So it's not a tax saving vehicle. That's not why people create it. There are many good reasons to create it. I could talk for an hour about those, but it is a testamentary substitute. And again, because so many people in New York City own co-ops, this will only work if the co-op agrees to put the shares of the co-op into this revocable living trust. 20, 30 years ago, most co-ops said, no, we're not going to do this. That firm rule has changed because more and more people wish to create these type of trusts. But there are still some co-ops that absolutely won't allow it. Those that do allow it can cause the client to go through a very expensive process to make it happen. And I've encountered some co-ops that have quotas that say, well, we have 200 shareholders in our building, and we already have 10% that are in trust. So we won't allow another one until some of them die, and then we'll allow another one to create a trust. So we encounter that when people who own co-ops wish to create trust. You cannot put a qualified retirement account into a living trust. The trust cannot own such an account, but you can list the trust as the beneficiary on a qualified retirement account. Now, very briefly on taxes, and again, I could talk for an hour or more about estate taxes. Right now, today, the exempt amount for federal estate tax is $13.99 million. That means, excluding spouses, and I'll get to that in a minute, you can leave 13.99 to anyone, children, friends, siblings, anyone, and not pay federal estate tax on that amount. Next January 1, that amount is projected to decrease to $7 million under current law that Congress passed. What I was telling people for the past 5 years or so was, we're going to have to wait and see who controls Congress in 2026 to get a sense of what might happen. Well, we now know. I mean, barring a lot of deaths in the two houses of Congress, the Republicans presumably will be controlling Congress and the White House in 2026. And so we expect that they will either increase the exempt amount or do what they did in 2010, which is totally eliminate the estate tax. The Republicans like to refer to it as the death tax. Given that it's now at almost 14 million for exempt amount, it affects a tiny amount of estates. But we'll have to wait and see what they do as to how many clients will be affected by the federal estate tax. If you're wondering what the U.S. estate tax rate is, it ranges from 18 to 40% of the taxable estate. I'll get back to that in a minute. In recent years, the federal government has something that's called portability. And without going too much into the weeds, portability means I have an exempt amount of let's say $14 million. I can leave that to my children, my friends, my siblings. I can also leave anything to a spouse. There's an unlimited spousal exemption. Spouses inherit totally tax-free, whether it's $1 or $1 billion. Both federal and New York State recognize an unlimited spousal exemption. So when we talk about the exempt amount, it's for people other than a spouse. And charities also have an unlimited exemption under both taxing systems, federal and New York. Whatever you leave to charities is not considered part of your taxable estate. What I started to say was fairly recently, Congress amended the Internal Revenue Code to provide for what we call portability. And that says, if you don't use your full exempt amount when the first spouse dies, this only relates to spouses, married couples. So if one spouse dies and leaves all of his property to his spouse, as I just said, that goes totally tax-free. There's no estate tax. So the dead person didn't use any of the 13.99 exempt amount for children and siblings, etc. Portability says that unused amount, that unused exempt amount, is carried over to the spouse, so that when the spouse dies, the spouse gets, let's say it's the wife, the spouse gets her exempt amount, whatever it is on the date of her death, because it does change, plus the unused amount that her husband's estate never used. The result of this is, of course, by the time the second spouse dies, there could be a huge exempt amount. And that's only under federal law. Under New York State estate tax, the exempt amount right now is $7,160,000. So it's roughly half of the federal amount. The tax rate is much lower. It varies from 3.06% to 16%. New York does not recognize portability. So if you don't use your exempt amount when the first spouse dies, you've lost it. There's no carryover for the surviving spouse. New York also has a ridiculous rule that we refer to as the cliff. And let me explain what that means. Under federal law, until you get to the exempt amount, let's say it's 14 million, rounding it off, there's no estate tax. So until you get to 14 million, all of that money, 14 million, passes tax-free. The minute you get to 14 million, the next dollar is taxed. The next dollar is taxing on it. But nothing below that is taxed. New York says, no, we're not going to do it that way. And I'm simplifying this for purposes of this conversation. But basically what the cliff says is, once you get to the exempt amount under New York law, we're going back to $1 to tax. Okay? All that money that's under the exempt amount, which is now roughly 7 million, will be taxed if the taxable estate goes over that amount. The taxable estate includes whatever's not left to a spouse or to a charity. And the way we deal with this, it's not a foolproof way, but we recommend to clients that we think might be near the cliff when we sit down and see what their taxable estate will be. And of course, we don't know what the exempt amount will be when they die. We don't know what their assets will be when they die. But we include in the will what we call a Santa Claus provision. And it says, and I'm really paraphrasing because it's very legalese, but it says, if when I die, my estate is going over the cliff, I authorize my executor to make a gift to charity. And you can specify the charity or leave it to your executor's discretion. And that means that piece of your estate is not subject to estate tax because it's going to a charity. That brings it under the cliff. It only works if the taxable estate is right at the cliff. I mean, if it's 3 times what the cliff is, it's not going to work. because you're not going to leave all that money to charity. You're going to pay the estate tax and, bite the bullet. But we do include a Santa Claus provision to protect those estates that are right near the cliff under New York estate tax law. As I mentioned, there's a total spousal exemption. Spouses don't pay estate tax. The same with charities. As far as apportionment means when I die, who pays my estate tax? Now, it's an estate tax. Some states have what they refer to as inheritance taxes. What does that mean? It means I inherit from an estate, but I have to pay the state, whatever state I'm in, not New York, a tax based on what I've inherited. Both the federal law and New York law says, well, we don't really have an inheritance tax. We have an estate tax, meaning the tax comes off the top of the estate. It's the executor's obligation to pay the estate tax before he starts distributing money to everyone. It's his obligation. He's required by law to do that. And the question is, well, how does he apportion the estate tax? And New York law says it should be apportioned by each asset. So if I leave Ian $10,000, I've got to take a pro rata share of that 10,000. If I leave someone else 100,000, I have to do the same. You can alter that in a will, and most people do, by saying the estate tax shall not be apportioned among each of the beneficiaries, but shall be paid from my residuary estate. The residuary estate is what we refer to as the pot. Everything else, after you leave 1,000 of this one, 10,000 of that one, my diamond jewelry to this one, then you get to the residuary estate. Now, of course, if there isn't enough money in the residuary estate to pay the estate taxes, then it has to be apportioned. But if there is, the client can control where the taxes will come from. I'm going to get to trusts. We already heard a couple of questions. Again, I could talk for many hours about different trusts. The trust I already mentioned, the Revocable Living Trust, is not a trust that is included in a will. It's a substitute for a will. So it's created while the person is alive. It's a separate document. It has its own rules. The trusts I'm going to talk about right now are what we call testamentary trusts. They're inside the will. They don't exist until the will is probated after the person dies. Until then, it's just words on a piece of paper. But once the person dies and the will is submitted to surrogate's court and accepted for probate, then the will becomes an operative document, and the trusts that are mandated in the will come to life. Until then, they're not alive. They're waiting to become alive. And there are different types of trusts. There are often marital trusts, particularly in a second marriage situation. If the testator has had more than one spouse, and particularly children from an earlier spouse, he may decide that the money leaving to his second wife will be kept in a trust. Why? He doesn't want to leave everything outright to the wife, because she might leave it to the children from her, her prior relations, or her tennis instructor, or whatever. He wants to make sure the money eventually goes to his children. So he creates a trust. And a trust, there are all variations on a trust. But a trust basically says, while you're alive, you'll get the income from this trust. But you can't get your hands on all the money because the trustee has control of it. I'm going to get back to who the trustee is. And then when you die, meaning second spouse, I say who gets those monies. And in a marital trust, it's typically the children from a prior marriage. And that's done to protect them. You want to make sure the second spouse enjoys the money while she's alive, but doesn't get to just spend it all and deprive the children of the benefit when she dies. There are disclaimer trusts.
Gave nothing to Gary and Randy.
I'm sorry.
No, never mind.
Okay. There are disclaimer trusts. Disclaimer is a term of art, very important under the Internal Revenue Code, where someone who inherits money under a will disclaims it, saying, I don't want it. Now, why would someone do that? Typically, a spouse might do it to fund another trust that I'm going to get to. So, unlike a second marriage situation, if there's only been one marriage and client and the spouse have been happily married for many, many years, and they have children from their relationship, and there's no prior relationship, and there's no children hanging out from another relationship, rather than creating a marital trust that restricts the use of the money for the surviving spouse, the will might say, if my spouse disclaims any money, and we leave it to the discretion of the spouse. We don't leave it to the discretion of the spouse in the marital trust because we don't want to leave it to her discretion. We want to mandate it. But if it's a disclaimer trust, the surviving spouse will sit down at the time of the death of the first spouse with an attorney, with a financial advisor. What's the tax rule today? What's my financial situation today? What's the family situation today? And maybe I'll disclaim some of my inheritance, all of it or some of it. And if she does that, then the will says, well, where does that disclaimed asset go? And I want to emphasize that the Internal Revenue Code has very strict rules about disclaimers. These rules must be followed within 9 months of the date of death, which is also the time to file estate tax returns. Because if the rules are not followed, the taxing authorities take the position, well, this disclaimer is really a gift. The spouse who's disclaiming is making a gift to whoever gets the money upon the disclaimer. And that might trigger a gift tax, and we don't want to do that. So it's very important, and this is not done when the will is being drafted or signed, but it's very important after the client dies that a disclaimer is done within 9 months of the date of death. And very frequently, the will say, if any assets are disclaimed by my wonderful spouse, those assets go into what we call a credit shelter trust. We already talked about what a trust is. Credit shelter means I haven't used all of my exempt amount. So when I die, if any amount is disclaimed, we're going to say that's part of my exempt amount. But instead of giving it to my children outright, because they fall under the exemption rules, we're going to put it into a trust. And that's for the benefit of the surviving spouse. The credit shelter trust says, while my surviving spouse is alive, she gets the income from this trust. So even though she no longer owns it, or she never owned it, it was the decedent's asset, she gets the benefit of the income, dividends, interest. And then the terms of the credit shelter trust that are written in the will say, when the surviving spouse dies, my children get whatever's left in the trust. And the benefit of that, the takeaway for that is those monies that go to the children upon the second spouse's death, whether it's a year later or 30 years later, are not included in anyone's taxable estate. They pass tax-free to the children. So that's why people create credit shelter trusts. That, and I know that's complicated, and I've simplified it for purposes of this conversation, but it's very common, and it's got to be written into the will. If it's not in the will, it won't happen, because the spouse can disclaim property, but then what? The will doesn't say it's going into a credit shelter trust. If it doesn't say so, it will go into the residuary estate, and then it will be part of a taxable estate. So we don't want that to happen. Another common trust in a will are trusts for minors. And by minor, I don't necessarily mean a person under the age of 18, but it could be. But the client decides who's a minor. A minor. Is it 20? Is it 21, 25, 30? I mean, when clients get to 40, I try to discourage them from controlling from the grave for too long. But there might be good reasons. I mean, the child, even though the child may be an adult, is not good with money. And so the client decides in the will to say, if my daughter Mary inherits any money, it shall be placed in trust until she reaches a certain age. And certainly clients do that, particularly if they're planning for grandchildren, some of whom might not even exist when they're writing their will, but we still plan for them. And they may be 3, 4, 5 years old when the person dies. So they don't want to give them a check for what could be a significant amount of money. We want to make sure the money goes into a trust. And the trust will say, usually, the income will be paid to the minor when the trust exists. And then when the trust ends, they'll get a lump sum payment. Most trusts for minors, they don't have to, but most trusts will also say, let's give a periodic payment of principal to the minor. So let's say the trust ends at age 30. Well, when the child reaches age 21, the will might say pay them 10% of what's in trust. And then when the child reaches 25, pay them another 10%, on and on, until you reach the age where the trust ends and the child gets a check for the full amount.
So maybe, Kevin, if you finish that thought with that, then I wanted to keep it kind of an hour for everyone. Maybe I'm sure everyone has a question, or unless you wanted to hit one thing that you thought was really critical.
I didn't talk about fiduciaries. Those are executors. Executors execute the will, whatever the will says. A trustee is the person who performs the trust. If it's a credit shelter trust or a marital trust, the trustee cannot be the surviving spouse alone, but can be the surviving spouse with someone else, a co-trustee like one of the children. You should always have alternates. And What else? There are miscellaneous clauses in a will. We call one of them an interim clause, which means if anyone contests this will after I die and they lose that contest, gotta lose, they'll get nothing. So it's a warning against people who are unhappy with a will from contesting it. Now, it only works well if you leave them something in the will, because what are they giving up if they contest? If they contest and they lose, they walk away without anything. But if you leave them, say, $25,000, they have to decide if it's worth taking the chance of losing that 25,000 if they contest and lose. And the other documents that we normally prepare for clients, what we do estate planning, are power of attorney, healthcare proxy, living will, and it's no longer so recent, but for the past 20 plus years, New York has permitted clients to designate who will take care of their bodily remains. And this is important, particularly when there isn't a spouse who might be the obvious person to take charge of someone's body. But if it's a single person, particularly one without children, or children who might disagree for religious reasons, they should set forth how they want their body handled, whether it's cremation, burial, etc. So that's all part of estate planning. And that's the difference between estate planning and just give me a simple will.
And I imagine anyone who kind of joined us thinking they would go online and download a form probably is going to have a second thought. That's very, very helpful. There's lots to think about.
Good. Any questions?
So let's try to open up for questions. Who has a question you want to ask? You can unmute or raise your hand and I'll unmute you if you're muted.
Yeah, just a question to get the conversation going too. In the trust, the assets remain as they were upon the time of death, right? If you hold stocks, they remain as stocks.
Well, let me interrupt you. The trustee has charge of those assets. If the trustee feels that the stock market is not a good place to keep those assets for the benefit of the beneficiaries, maybe he'll switch to bonds. So the trustee stands in the shoes of the client who created the trust and has the power to do whatever the client would have done under a legal obligation to do it all for the benefit of the beneficiaries. So any trustee who made foolish, it's the prudent investor rule that I know Ian is very familiar with, that says you've got to manage these monies prudently for the benefit of the beneficiaries. And the tension often is between managing those monies for the so-called income beneficiaries, such as the wife that I mentioned while she's alive. So investing the monies that kick off income and investing the monies for the benefit of what we call the residual beneficiaries, the persons who will inherit when the wife dies. That can be two different investment strategies. And the trustee has to keep both in mind and not do something that's totally to the detriment of one class of beneficiary as opposed to the other. So I'm sorry for the interruption, but I just wanted to make that point. Did you finish?
Thank you, Kevin. That was exactly the question.
So, I mean, one thing that I hear a lot, my clients said, "Oh, I was at a cocktail party and somebody told me I need to do this," or I went to a seminar to get a free lunch or something in Miami, and they told me, "Oh, I need to do that." And a lot of folks scare people either with estate tax. Oh, you got to do something because of estate tax, even if without even knowing how much their estate tax. Or, oh my gosh, probate. You got to do whatever you can to get out of probate. So it's important to just consult an attorney wherever you are to really, before you kind of start going crazy, to really work through a lot of these issues. So Kevin, what is your experience with probate? The other question I would like to, other point to bring up is if you do create a trust, make sure you put your assets in the trust. I've seen that too,
Yes.
where people go through all this effort, create trusts and so forth, and never retitle any of their assets, their bank accounts, their stock, their investment accounts, their house, so it's really important to do that, or else you just really ended up with nothing. But is probate a real challenge? Is probate something everyone wants to avoid that at all cost? It seems.
Can I
No.
jump in with a question here that kind of
Sure.
relates to that?
Absolutely.
Go ahead.
Um, I was interested in that little story you told about jewelry, transfer of jewelry via a letter outside of the will. I wonder, is that for more minor things, or could that pertain to real estate?
Well, no,
No way.
you would never do it for real estate.
All right, so that leads to really the big question here. Then you followed that up with talking about a testamentary substitute.
Yeah.
And my question would be, if you had a house, and I'll do just simple example here. I've got $1 million house, and I have significantly more larger assets, but the house is worth $1 million, and I have 2 daughters, and I want to treat them equally in my will, but I want my house to go to my elder daughter. Is it more of an advantage to effect that transfer through the testamentary substitute route? Is she being a joint owner with her, and when I die, it's hers. It passes right by the will? Or would I be more to do the trust route, as Ian was just bringing out, making sure to get it into the trust? Which way would make more sense?
Okay. Well, we're doing apples and oranges here. I mean, let's talk about putting someone down as a joint owner. So you're now living with this person. I mean, what's the downside of that? You're living with this person as a joint owner while you're alive. Do you want that? Maybe you do. Maybe you don't care.
No, I'm ready to give her the house tomorrow. I'm ready to put it in her name tomorrow.
Well, that's not what you said. You said you would put her as a joint owner. If you want to give it to her outright, you have now triggered a gift tax because you've given her a valuable asset. Now, New York does not have a gift. I don't know where you're located. Some states have gift taxes. New York, believe it or not, does not, unless it's a gift made within 3 years of death and the asset is clawed back into the estate to be part of New York's taxable estate. But under the federal estate and gift tax code, there is a gift tax, and it can decrease the amount of your exempt amount when you die. So you're talking about 2 different scenarios. If you want to gift it to her while you're alive, okay, you can do that, but it's no longer your asset, it's hers. She can do whatever she wants with it. She can sell it. She can tell you to get away. You're not going to live here anymore. I don't know what the terms.
I'm assuming I can put a condition in that it's until I'm dead.
Okay, then we're really getting complicated. Then you're asking for something called a life estate, and you're retaining a life estate, and there are tax consequences for that. And we don't encourage life estates because they can often lead to disagreements with the person who has the life estate and the person who owns the property. If you put her down as a joint owner, that's nice, but you're now owning the property with another person. That might work out. What if relations go sour?
As a joint
Can
ownership,
can I interrupt and ask a question? Can I interrupt and ask a question, which is, what if I sell my $1 million house to one of my daughters for $1,000? It's no longer a gift; it's a sale. What about?
No. That's not correct.
Just asking.
I know the taxing authorities will say you did not sell it for fair market value. So you made a gift of the difference.
Okay.
But I want to go back, if I made it, to Ian's question about probate, because you will hear late night, on late night television, avoid probate, avoid probate. Okay. Probate in New York, oddly enough, is not a terrible onerous process. And I say oddly enough because New York is known as being complicated no matter what it does. Until COVID, the probate process ran very smoothly. COVID started, we had problems. We're now recovering from those problems, and probate is moving more smoothly. Are there probates that don't move smoothly? Yes. And those fall into a couple of categories. One may be where someone's objecting to probate and they start a will contest that could last for years. That's highly unusual, but it happens. And as Ian mentioned when he introduced me, I do surrogate litigation. I've been involved in will contests. They can last a long time and delay probate, but they're highly, highly, highly unusual. It's got to be worth the while for the person who's objecting to go through the litigation process and hopefully win. And most of them are settled, but not all. The other complication for probate, again, I'm talking about New York law, I'm not talking about the other 49 states. New York requires that when someone dies and their will is filed for probate in surrogate's court, the next of kin, whoever they are, must be put on formal notice and be served with what we call a citation. They don't have to be left a dime. No one other than a spouse under New York law is entitled to an inheritance unless the spouse signed a prenup waiving the inheritance. Children are not entitled to any inheritance under New York law, but they may be the next of kin. So whoever your next of kin is when you die, maybe it's your spouse, maybe your children, maybe your siblings, maybe your nieces, nephews, maybe cousins, whoever they are, must be served with citations. And the problem becomes when we can't identify those people. I cannot tell you how many clients, single individuals, no spouse, no children, maybe they were only children, they have no siblings, so therefore no nieces and nephews. They don't know who their family members are. Yeah, I have a cousin on this side, but I don't know my cousins on that side. Well, those people have to be identified and served with citation. That process can delay probate. And that's a reason we encourage those type of clients to put their assets in a living trust. And as Ian said, it only works if they do it, if they fund the trust. Because if we go through the expense and bother of creating the trust, but they don't put every single asset they own, their house, their investment accounts, their tangibles, whatever they own, retitle them in the name of the trust so that when they die, the trust owns all these assets and there's nothing to go through probate. Question?
If you don't want to talk your question, out loud, you can use the Q&A box to, or unmute or ask me to unmute you.
Because when you go be satisfied.
I
Yeah.
think my question was pretty much answered. I was asking if you had to go through probate for just like investment accounts that have bennies listed, or is it just for real estate? But it sounds like I just have to put the will in for probate, and both in New York and New Jersey because there was a house in both states.
Oh, that's a very different question. If you have beneficiaries, those assets do not go through probate.
So
They're
if
a
I'm
testamentary.
I'm sorry, go ahead.
They're a testamentary substitute. beneficiary designations. The probate court does not have jurisdiction over them. But you raised a very different issue, which is one of the reasons why living trusts are important. Many clients own a house here in New York and another house in Florida or California. Because real estate is treated with such reverence by the law, going back to ancient England, and there are such strict rules about passing title to real estate. Each and every state that has jurisdiction over the decedent's real estate demands to have a probate proceeding in that state. So if you own a house in New York, or a condo, or even a co-op, and that's odd because a co-op is not real estate, but they insist. So if you own real estate in New York and you own a condo in Florida, you're going to have two probate proceedings, which is some expense for the estate. If you create a living trust and put those two assets into the trust, there's no probate in either jurisdiction. And that's why Susie Ullman is screaming about living trusts on late night television.
I'm going to have to interrupt and say I'm sorry, but we're going to have to leave. Thank you so much. It was really interesting and I enjoyed it very much. And thanks, Ian and
Thanks,
Kevin.
Bruce. Okay, thanks
Yeah.
for popping in.
Want to buy a house in Florida?
Me too. Thanks so much, Ian.
So once it's in the trust in that situation, Kevin, then it just passes to the beneficiaries.
Whatever one of the purposes of a trust document, and there's numerous purposes, is to be a will. We don't call it a will, we call it a trust, but it has testamentary provisions, just the way a will does within the trust.
Right.
So the trust document says, upon the death of the grantor, the person who created the trust, the assets will pass as follows, just the way a will says.
Okay.
But the asset has to be owned by the trust
Right.
in order for that to work. And that's what you were saying earlier.
So we have another question here. How are executors compensated?
Excellent question.
What formula is used to determine the amount? And how about out-of-pocket expenses?
Perfect. Yeah. Under New York law, an executor's commission is statutory. In other words, it's set by New York law. It's a sliding scale. It's 5% of the first 100,000 of probate assets. An executor only has control over assets that go through probate. So if it's passing to a joint owner or someone as a beneficiary designation, the executor has nothing to do with those assets. But if an asset goes through probate, the rule in New York is the commission is based on a sliding scale. 5% of the first 100,000, 4% of the next 200,000. It averages out, excuse me, at 3 or 3.5%. If it's an extremely large estate, like multiple millions, it could be like 2% of the probate assets. Any reasonable expenses, such as the executor's legal fees, such as the cost of cleaning out an apartment, which is often the most onerous thing that an executor has to do, those type of expenses, the estate will reimburse the executor.
Okay, good.
Tell them about the cars.
Now also there's the automobiles then also have another wrinkle too, right? They have to go by the state DMV rules and all that sort of
You
thing.
do. And to get back to your point earlier, when living trusts are created for clients, they often forget about their motor vehicle. And hopefully they will transfer the motor vehicle into the name of the trust. Now, I can't speak to the other 49 states. There may be states that won't allow that. I don't know. New York will, but you have to follow up on it and make sure it happens. Because again, if you die and you didn't move it into the trust, it now becomes a probate asset. It's not part of the trust.
Right.
And getting back to the executors commission, the client can say in the will, the executor will not be paid a commission. Why would the client say that? Maybe the client has 3 children and they've chosen one to be the executor, and they feel, look, they're going to inherit equally. I don't want the executor getting a bonus, even though the executor may be doing significant work. And I wasn't being facetious. Cleaning out the home is often the worst part of being an executor. But it is taxable income to the executor, whereas inheriting from the estate, unless there's an estate tax that's paid off the top, is paid to the heir tax free. So the client can modify the commission provision in the will.
Do you ever have a situation, Kevin, where someone comes in and says, I rent, I have investment accounts, bank accounts, and everything has a beneficiary or a joint owner. Do you ever send them out of the office and say you don't need a will?
No. Everyone needs a will. What if they win the lottery the day before they die? And it has no beneficiary designation. They should have a will. And in that case, it truly may be what every client wants, a very simple will. And I understand that. But until you sit down and inquire about all this and ask all these questions, you don't know. You don't know what the client has. But if they've done their planning correctly, and we encourage that, beneficiary designations, do beneficiary designations so you can. And now with this new New York rule of transfer of death of real estate, that's a big difference now. That real estate always had to pass through the will unless it was owned by a living trust. So that's a big difference now. That means a will may become unimportant. But if you don't have a will and there is a probate asset, it goes through intestacy. And the law says, who are my intestate heirs? In other words, your next of kin. And they may not be people you want to inherit, particularly if you don't have a spouse and children. Do you want cousins inheriting? Maybe, maybe not. Do you want nieces and nephews to be inheriting equally? Because that's what the intestate law says. If your 6 nieces and nephews are your intestate heirs, well, maybe you're close to 1 or 2 and you really haven't kept up a relationship with the others. So it's not a good idea to just shrug off, I don't need a will.
Now, like Nico was mentioning the case where he wanted a daughter to have the house, and assume we divide up everything. I mean, do you encourage clients to discuss these things openly with their heirs and say, hey, who wants the house? Who wants this? Who wants
Yeah, no,
that?
I've already worked all that out.
Right.
My whole family knows the house goes to my daughter, and I'm just trying to think, is it best to
I was
do it?
just wondering, do you often say, well, talk about it, before, or do you tend not to want to open that?
Well, because it depends on what the client is saying.
Yeah.
If the client says to me, I'm leaving everything equally, there really isn't much to talk about.
Right.
If the client says, this child has done very well financially, and I really don't think there's any reason to leave that child much, I said, well, you might make your feelings known so this person doesn't feel slighted.
Right.
If there's a real, for example, very recently I did a will. The clients, the husband and wife, had bought one daughter's co-op apartment. She's the owner. Her name is on the shares, but they paid for it. Well, they want the will to read that her inheritance will be decreased by the amount of money they spent on that co-op. So that they're being fair. These happen to be clients with 2 children. They want to be fair when they die. So, that should be discussed so that at the time, no one's carrying on and screaming, what the hell is this? So it really varies on what the situation is. I do have some clients who might say the last thing in the world I'm going to do is have a conversation about something. I'll leave it to my executor
Right.
to deal
Well,
with.
I see sometimes the aftermath afterward of, families that are, children that don't talk after that, and cousins who, that the whole experience of who got what or whatever becomes a thing that destroys the family afterward. And I guess that should be part of people's consideration, I guess. I mean, if they maybe not the primary consideration, but it's probably in there somewhere. But then again, they can control what their heirs feel anyway, so I guess maybe it doesn't matter.
Well, clients react differently. Some say, I don't care, I'll be gone.
Right.
Others feel that there's legitimate reasons. I mean, the one thing I do discourage is using a will to settle arguments. Do not, because it's rife for causing a will contest.
Right.
I mean, the example I can use is I once probated a will where the decedent said, I didn't prepare this will, but the decedent said, I leave my father. Now, the man who died was well into his 60s or 70s. I leave my father the sum of $10, which is more than he spent on me in his lifetime. When I inquired, I found out the father abandoned the family when the testator and his brother were very young, and he was getting back at him. Well, the surrogates court in New York said, you got to find the father and give him his $10. I mean, how absurd is this? But we didn't know where the father was. So we did a little detective work, and we found out the father had another family in Pennsylvania. He was deceased, but he had a daughter who very kindly said she would sign an affidavit saying that the man was deceased. That's all we needed to prove to the court. So we didn't have to give him $10. But we had to show her the will. And when we showed her the will, she was angry. She said, he was a loving father to me, but she still signed the affidavit. So don't use wills to settle scores. It will only harm and delay the probate process. Ian's correct. If there's any reason why people are being treated differently, have a conversation, write a letter that's outside the will. But usually people understand why they're being treated differently. And if they're not children, no one really, I mean, if nieces and nephews or cousins are being treated differently, who cares? I mean, seriously, they really have no right to complain.
Well, maybe unless we have any other questions, that was a good, we'll leave it at that.
Thank you very much.
The important lesson is go seek legal advice, when you're thinking about these sorts of things, and definitely do think about these things. Don't let it go. And, you don't have a will, you didn't put assets in trust. Don't let things go.
Good advice, Ian.
All right. Well, thank you, Kevin. Wait, did something come up? Oh, thanks for the informative. Thank you, Stephen, for coming. Okay, great.
Thank you.
Thanks, Kevin.
Thank
Good
you.
presentation, Kevin.
Very
Thank you.
much.
Have a good evening, everyone.
Good
You
night.
too.
Thank you.